Electric, Gas, and Water in the New York State Department of Public Service. I have been designated to serve as the alternate representing the chair of the New York State Board on Electric Generation Siting and the Environment, or as it is also known, the Siting Board. I call this meeting of the Siting Board to order. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board. Louis Alexander, alternate representing the Commissioner of the Department of Environmental Conservation. Dr. Elizabeth Lewis Michael, alternate representing the Commissioner of the Department of Health. Vincent Ravishir, alternate representing the Commissioner of the New York State Department of Economic Development. And John Williams, alternate representing the Chair of the New York State Energy Research and Development Authority. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda.
Thank you. We will begin with Case 17-F-0598, application of the Northside Energy Center, LLC, for a Certificate of Environmental Compatibility and Public Need pursuant to Article 10 of the Public Service Law for construction and operation of a solar electric generating facility located in the towns of Brasher, Messina, and Norfolk, St. Louis County. Presented by Maureen Leary, Administrative Law Judge, Department of Public Service. Richard Sherman, Administrative Law Judge, Department of Environmental Conservation. Dakin Leecakes, Chief Administrative Law Judge, Department of Public Service. Michelle Stefanucci, Chief Administrative Law Judge, Department of Environmental Conservation. Jason Zaire, Chief of Environmental Certification and Compliance, Office of Electric, Gas, and Water, Department of Public Service. And Robert Rosenthal, General Counsel, are available for questions. Judge Leary, please begin.
Thank you. Good morning, Chair Mitchell and members of the Siting Board. My name is Maureen Leary. I will forego the introductions. The gentleman to my right, Richard Sherman, on behalf of the Department of Environmental Conservation, and I were responsible for presiding over this proceeding. I do want to, and by the way, Judge Sherman was instrumental in writing the order, the proposed order now before you. I'd also like to recognize and thank the folks today in the room and on the WebEx for their participation, including Chief Judge Leecakes, Executive Deputy Thomas Congdon, Chief of Staff Jessica Waldorf, General Counsel Robert Rosenthal, Article 10 Senior Advisory Counsel Heather Benke, Markets and Regulatory Economic Supervisor Warren Myers, and on behalf of the Department of Environmental Conservation, Chief Judge Michelle Stefanucci and DEC Assistant Commissioner Catherine Petronis. They were instrumental in reviewing the issues presented in this case, the difficult issues, and really evaluating and spending a lot of time evaluating as a team the result that is currently before you in the proposed order. Since the passage of Article 10, the Siting Board has approved and issued certificates for 17 renewable energy projects, both wind and solar, all of which have moved New York toward its clean energy objectives. The Siting Board need not be reminded of the complexity of these projects and the Herculean task it can be to complete project review within the 12-month statutory timeframe set forth in Article 10. But that timeframe has consistently been met, and projects have been approved with conditions that serve the public interest. Today, after due consideration by and consultation with advisory staff, the Siting Board has before it today a proposed order that denies issuance of a certificate for the Northside Solar Energy Project because the record demonstrates that the project is not in the public interest. Essentially, the Board's denial is based on the applicant's failure to demonstrate that the project meets the mandatory criteria in Public Service Law Section 168(3), insofar as the record fails to show that the project as proposed minimizes and avoids adverse environmental impacts to the maximum extent practicable, including impacts to freshwater wetlands and threatened and endangered species. And the project as designed fails to comply with applicable and substantive requirements of state environmental laws and regulations, including specifically Environmental Conservation Law Article 11, which governs the protection of threatened and endangered species and their habitat, and ECL Article 24, which governs the protection of freshwater wetlands. As the Siting Board is aware, for it to issue a certificate, Article 10 includes these required findings by the Siting Board. and they are specifically set forth in the statute. And without these required findings, the Siting Board cannot conclude that the project is in the public interest. This is yet a third criteria that the project fails to meet. The order before you is based upon an extensive evidentiary record, including the initially filed application and subsequently filed supplemental and updated application materials. There's also expert testimony and exhibits, proposed certificate conditions, and site engineering and environmental plan guidance. The parties also submitted legal briefs on the issues presented that are still in dispute. Despite this extensive record and the briefing, the order before you finds that the record does not support the issuance of a certificate. I will briefly describe the project, sketch the procedural background, including notice and public participation, outline certain relevant undisputed facts, and explain the legal dispute among the parties that the Siting Board is asked to resolve in this order. I will then turn to the findings in the order itself. The description of the project includes Northside's application to construct and operate a 180 megawatt commercial scale solar electric generating facility in the towns of Brasher, Messina, and Norfolk, all located in St. Lawrence County, New York. The proposed facility would have included hundreds of solar arrays of between 15 and 18 feet in height and would cover approximately 1,400 acres of a 2,235 acre project site. It would also include several miles of access roads, underground collection system lines, a collection system substation, parking areas, staging and laydown yards, and a point of interconnection facility with associated components. Project construction would involve clear-cutting trees and vegetation, grading and filling portions of the site, burying collection lines, construction of a substation, as well as roads, parking areas, and laydown yards. With respect to the parties to the proceeding and the procedural background, in addition to the applicant, the active parties including staff from the Department of Public Service, the Department of Environmental Conservation, the Department of Agriculture and Markets, as well as the host towns of Brasher, Messina, and Norfolk, and the County of St. Lawrence. Public notice and comment during the Article 10 review process for this project was fair, robust, and open. It included public participation and input from the host communities and the towns and County of St. Lawrence. Both the towns and the county were afforded pre-application and application stage intervenor funds in order to foster their participation. Both were represented ably by counsel and retained a well-recognized consulting firm to review the application. Public notice about the project was provided at significant milestones during the proceeding, from the filing by the applicant of the Public Involvement Program Plan to the filing at the very end of the proceeding of proposed certificate conditions and related settlement documents, related partial settlement documents. Northside's application was made available to the public through the Department of Public Services Document and Matter Management System and its website, through Northside's website, and was available in town halls and local public libraries in the project area. Notices related to the project were published in area newspapers multiple times. In October 2021, the department sponsored afternoon and evening public statement hearings at which speakers expressed both opposition to and support of the project. These comments were transcribed and are part of the record in this proceeding. In addition, the public submitted 8 written comments expressing both support and opposition. In June 2020, Northside filed a preliminary scoping statement and thereafter filed agreed-upon stipulations with the other parties that outlined the scope and methodologies of the studies to be undertaken in support of the application. In a February 4, 2021 letter, DEC provided Northside with its preliminary wetlands assessment and identified extensive potential project impacts to freshwater wetlands throughout the 3,500 acre project area. DEC raised concerns regarding the project's impacts on wetlands and expressly requested that Northside delay filing its application in order to continue discussions about how these impacts would be addressed. 2 weeks later, however, on February 19th, Northside filed its application without resolving the wetlands issues. In a July 9th letter, the Siting Board chair notified Northside that its application complied with Article 10's filing requirements, Thereafter, the examiners established a procedural schedule and set a date for commencing an evidentiary hearing because at that point the 12-month time frame had begun to tick. On July 23, 2021, Northside filed a notice of impending settlement negotiations, and the parties enter into discussions over the next 6 months. The agency parties filed testimony in November 2021, and Northside filed rebuttal testimony in December. In November, a partial settlement among the parties was filed and includes certificate conditions and a site engineering and environmental plan. DPS and DEC staff both asserted objections to numerous certificate conditions related to wetlands and endangered species, among other things. In January 2022, a revised partial settlement was filed, which addressed the limited issue of Northside's post-certificate compliance filing of a net conservation benefit plan for threatened and endangered species. Even after the revised settlement was filed, many certificate conditions remained in dispute between the applicant on the one hand and DPS staff and DEC staff on the other. These disputes involve the protections that should be afforded to freshwater wetlands and, in a related sense, to the threatened and endangered species found at the project site. In February and March 2022, the parties submitted briefs addressing the disputed legal issues. Notably, the parties agreed that the issues in dispute were legal rather than factual in nature, and they waived their respective rights to cross-examine witnesses at an evidentiary hearing. Thus, there is no factual dispute in the order before the Siting Board today that requires resolution. Here are the undisputed facts. The factual context is very important, and it is basically what the Siting Board's decision turns upon. Approximately 1,504 acres, or 67% of the project area's total 2,235 acres, are freshwater wetlands that were identified and delineated by the applicant itself as a part of its application, which in the order refers to Application Exhibit 22, which was updated on a number of occasions. Some of the delineated wetlands are mapped, that is, they appear on the official state freshwater wetlands maps promulgated by DEC pursuant to ECL Article 24. Some of the other wetlands, however, are not mapped, but are contiguous to or adjacent to mapped wetlands, meet the ecological criteria for a wetlands, and/or are part of the same wetlands complex. In total, there are approximately 37 wetlands and 11 streams at the project site. Northside's own experts estimated impacts to at least 507 acres of wetlands. The DEC Wetlands and Streams panel testified that its on-site field investigation and inspections, quote, revealed that 10 different DEC mapped wetlands are actually all part of the same wetland complex, end quote, and that, quote, the unmapped wetlands, inserted unmapped, it is not a part of the quote, the unmapped wetlands located between the mapped wetlands are indistinguishable as a result of their contiguity, end quote. DPS staff, for its part, asserted that as a result of Northside's position to minimize or avoid impacts to only mapped wetlands, the record lacks sufficient information on which the Siting Board can rely in making its findings that such environmental impacts have been minimized and avoided to the maximum extent practicable. DPS staff further testified that its own observations of on-site field conditions, quote, cast further doubt on the reliability of the applicant's calculated impacts as presented in the application, end quote. Northside offered as minimization and avoidance measures that unmapped wetlands in, quote, areas previously disturbed by agricultural and practices and logging activities were given preference for the placement of project components. Northside also proposed that in lieu of compensatory mitigation, minimization, or avoidance measures, it would use, quote, best management practices instead. Northside further asserted that due to a, quote, multitude of siting constraints, the project's layout cannot be reconfigured to further avoid or minimize impacts to non-mapped wetlands, end quote. In addition, and related to the wetlands impacts, 7 threatened and endangered species and 2 species of special concern protected under ECL Article 11 were identified, again, by the applicant to be in the project area. Some were identified as exhibiting essential behavior in the project area. That is, they were living, nesting, roosting, feeding, foraging, reproducing, etc. This means that at least part of the project site can be characterized as essential habitat for threatened and endangered species. The identified threatened and endangered species located there or identified there include the endangered short-eared owls and golden eagles. The threatened species are Blanding's turtles, northern harriers, sedge wrens, upland sandpipers, and bald eagles, and the species of special concern include the vesper sparrow and the grasshopper sparrow. I'll now turn to the legal dispute. The legal dispute among the parties is very straightforward and can be summarized as follows. Whether impacts to delineated wetlands that are not on the state's official wetlands maps must nevertheless be minimized and avoided to the maximum extent practicable and subject to Article 24's compensatory mitigation requirement, whereby the applicant would be required to replace or restore impacted wetlands. Here, Northside asserted during the proceeding that it had sufficiently minimized and avoided mapped wetlands by citing components in areas that were unmapped, and that unmapped wetlands should not be subject to minimization, avoidance, or mitigation requirements. Northside further asserted that the project would no longer be economically viable if the siting board imposed requirements, that is, avoidance, minimization, or mitigation requirements, to the hundreds of acres of wetlands impacted by the project. Northside also resisted any layout or design changes and proposed no alternatives. Belatedly, however, they removed 100 acres of forested wetland that were under federal jurisdiction in accordance with communications they had with the United States Army Corps of Engineers. The siting board's proposed order with respect to the wetlands first notes the importance of this resource to the state, including the functions and benefits during climate change. This order also recognizes the lack of clarity regarding the total number of acres of freshwater wetlands that would be adversely impacted by the project. The siting board relies on the testimony of Northside's experts, which conceded impacts to 507 acres of wetlands. The order therefore assumes that at least 507 acres will be impacted, while recognizing DEC's testimony indicating that a greater number of acres would be impacted. The proposed order also notes that the record reflects no dispute that the wetlands delineated by Northside in its own application cover approximately 1,500 acres. That these delineated wetlands consist of both mapped and unmapped wetlands, and that nearly all the wetlands are contiguous. The order finds that separate and apart from DEC's Article 24 authority, the siting board has a separate and broader authority under Article 10, specifically Public Service Law 168.3, to address this project's environmental impacts and to assure such impacts are minimized and avoided. The order finds that the siting board's Article 10 authority to require such measures is not constrained by Article 24. The order before you notes that the disputed legal issue regarding whether unmapped wetlands should be afforded Article 24 protection was settled decades ago by the Court of Appeals. In Wettinger v. Goldberger, the court rejected the narrow definition of freshwater wetlands that Northside argues here. That is, that the term applies only to mapped wetlands, obviously subject to DEC's regulatory authority. In Wettinger, the court held that the term freshwater wetlands could not be interpreted so narrowly, because to do so would ignore other relevant and integrated portions of the statutory scheme and the legislative purpose behind Article 24 to protect this important state resource. The proposed order recounts DEC's historical implementation of Article 24 and cites other judicial and administrative decisions that support the siting board's conclusion that unmapped wetlands should be subject to protection and, more importantly, to Article 10's requirement for a project to minimize and avoid impacts. In addition, as the order before you notes, the siting board has previously addressed the issue of mapped and unmapped wetlands in the Alley Cat Wind Energy Article 10 proceeding. There, the ALJ's recommended decision determined that unmapped wetlands extending beyond the mapped wetlands would be subject to Article 24 and to the siting board's jurisdiction to require a minimization and avoidance measure. The Siting Board adopted the ALICAT recommended decision in its June 2020 order, finding, quote, "It is undisputed that unmapped freshwater wetlands are jurisdictional wetlands entitled to the protections of Article 24. It is also important to note at this juncture the difference between the number of acres of impacted wetlands here and the number of acres impacted in other cases that have come before the Siting Board. In the order before you, the Siting Board finds that impacts to 507 acres is unprecedented in an Article 10 proceeding. Indeed, the Siting Board has approved several Article 10 proceedings that have had a far more limited impact to wetlands than the impacts evident here. For example, in the recent April 2022 Excelsior Energy Order for a solar facility, impacts to wetlands proper were completely avoided by the applicant, and impacts to adjacent areas, that is, those areas within 100 feet of a wetland proper, totaled only 0.31 acres. Similarly, the Siting Board's November 2021 Trelina order recognized that there were no impacts to wetlands proper, and impacts to adjacent areas, again within 100 feet, totaled only 4.8 acres. Finally, the Siting Board's August 2019 East Point order noted that wetland impacts were limited to only adjacent areas and totaled about 0.34 acres. Thus, both qualitatively and quantitatively, the extent of wetland impacts in this proceeding are far different than the impacts in those cases. Turning to the threatened and endangered species, with respect to those impacts, the order notes that the record reflects no dispute that those protected species have been documented in the project area and that certain species perform essential behavior there, meaning that the project area is in part habitat for these species and the project could result in the taking of such species, which is prohibited under Article 11. In the order before you, the Siting Board determines that Northside has failed to carry its burden and demonstrate that the project's adverse impacts on wetlands and threatened and endangered species have been minimized or avoided to the maximum extent practicable, and that the project as designed will comply with applicable environmental laws. These findings are required, as I previously noted. The order determines, in the absence of those findings, the Siting Board cannot find that the project is in the public interest. Of further note is that the order before you makes the requisite finding under Section 7.2 of the Community Leadership and Climate Protection Act, or CLCPA. The order notes that the Siting Board's denial of the certificate for this project is consistent with the CLCPA, and as the Siting Board is aware, the state is on course to achieve its renewable energy and greenhouse gas reduction objectives. In conclusion, we recommend the Siting Board's adoption of this proposed order denying the certificate for this project. This concludes my presentation. We are available to respond to any questions that the members of the Siting Board may have. Thank you.
Thank you very much, Judge Leary, for your comprehensive summary of the item before us. I have no questions. Let me turn to my fellow board members for any comments or questions. Mr. Alexander.
I have a couple of comments. First, I would also like to thank Administrative Law Judge Maureen Leary for her presentation. The presentation, in my view, well sets forth and describes matters at issue. In the weeks prior to our meeting today, I have reviewed the underlying record, including but not limited to the exhibits, the parties' briefs, and the panel testimonies, as well as our Siting Board prior orders. This order before us, in examining freshwater wetlands, threatened and endangered species issues, as well as CLCPA consistency, provides a reasoned, thoughtful, and thorough evaluation. In my judgment, the record of this proceeding fully supports the order that is before us today. Thank you.
Thank you. Dr. Lewis-Michael?
No comments.
Mr. Ravishir?
I have no questions or comments.
Thank you. Mr. Williams?
No comments or questions.
I'll now call for a vote. My own vote is in favor of the recommendations as described. Mr. Alexander, how do you vote?
I vote in favor.
Dr. Lewis Michael?
In favor.
Mr. Ravishir?
In favor.
And Mr. Williams?
In favor.
The order is approved and the recommendation is adopted. Secretary Phillips, is there anything further to come before us today?
There's nothing further.
Thank you. We are adjourned.